A Supreme Court warning is turning into a full-on legal war. And if your city makes you wait months for a carry permit, that delay may not be just annoying anymore. Pause. It may be the very thing that gets the whole system challenged. Quick question before we continue. Are you subscribed? Because this channel tracks the legal changes most gun owners hear about way too late. Hit that button now, because what I'm about to explain could make the difference between understanding your rights and getting blindsided by a bad local policy. Here's what just happened, and here's the part that gets people fired up. A lot of headlines are making it sound like the Supreme Court just dropped an emergency order that instantly ends public carry delays all across America. That is not exactly true. There is not a final nationwide Supreme Court ruling today that wipes out every permit delay in every state. But here's why people are talking like that. The court already lit the fuse in the Bruen decision, and now lower court fights, DOJ action, and fresh lawsuits are pushing that warning into the real world. Let me break that down for you in plain English. In Bruen, the Supreme Court said, regular law-abiding people have a right to carry a handgun in public for self-defense. That was the big headline. But here's the part nobody talks about enough. The court also said states with so-called shall-issue permit systems are not automatically unconstitutional. A shall-issue system is simple. If you meet the listed rules, like a background check or training, the state should issue the permit. No begging. No proving you are extra special. No trying to convince a government official that your life matters more than someone else's. But here's the crazy part. The court also warned that even a shall-issue system can become abusive. In other words, a state cannot pretend to respect your rights while slow-walking your application into the ground. The justices specifically pointed to long wait times and huge fees as possible constitutional problems. That matters a lot, because once the Supreme Court says that out loud, it gives gun owners a roadmap. It tells lawyers exactly where to attack. Think about it like this. If your county says, sure, you can exercise your right, but then makes you wait 10 months, 12 months, or even longer, what do you really have? A right on paper, not a right in your hand. And for many people, that is the whole fight right now. Have you ever wondered why some local agencies seem fine with dragging their feet? Because delay feels cleaner than denial. A hard no can be appealed fast. A bureaucratic stall can hide behind paperwork, staffing excuses, and phone calls that never get returned. That is what makes this issue so dangerous. The government does not always have to say no to shut you down. Sometimes it just says, we're working on it, until another year goes by. Here's a hypothetical example to explain this. Imagine you live in a rough area. You work late. You walk to your car in the dark. You follow every rule. You fill out the application. You pay the fees, you take the class, you send the documents, then you wait, and wait, and wait. 6 months pass, then 9, then a year. During all that time, the state gets to say, we didn't deny you. But in real life, you still cannot carry. That is why delays matter so much. Now, this is where it gets interesting. The legal fight is no longer just theory. The federal government itself started moving on this issue. The Department of Justice announced an investigation into the Los Angeles County Sheriff's Department over concealed carry permit delays. That alone was huge. Why? Because it showed this was not just gun groups complaining online. It meant the federal government was saying, hold on, these delays may be violating the Constitution. And the facts that came out were wild. The DOJ later filed a lawsuit saying Los Angeles County had thousands of applications in the pipeline, approved almost none of them during a key period, and made people wait an average of about 9 months just to begin processing. Some interviews were reportedly scheduled out insanely far. That is the kind of fact pattern that gets judges' attention fast, not because it sounds unfair, but because it looks like a system that exists to wear people down until they give up. Let me say something important here. This does not mean every permit office in America is now illegal. Don't make that mistake. A lot of gun owners hear one big case and jump straight to, that's it, permits are dead. Not so fast. What it does mean is that courts now have a very clear warning from Bruen, and real-world examples are stacking up that test, that warning. If you're finding this helpful, imagine what you'll learn in my next video about the 5 words that can protect you when an officer starts asking questions about your gun. Subscribe so you don't miss it, because these legal details matter most when things get tense in real life. Now let's talk about why people are calling this an emergency issue. It's not just because it sounds dramatic, it's because rights delayed can become rights denied. That phrase is not just catchy, it gets to the heart of the problem. The whole point of a constitutional right is that the government cannot make you wait forever to use it. Imagine if a city told a church, sure, you can worship, but first wait 14 months for a form, or told a newspaper, you can publish, but only after we get to your file next year. People would lose their minds. Yet with gun rights, some local agencies seem to think delay is no big deal. Most people think the legal fight is only about bans. But the truth is, Procedure can be just as powerful as a ban. A hostile office does not always need a new law. It can use old-fashioned delay, more paperwork, more appointments, more surprise document demands, more silence. Then, after months of waiting, maybe it asks for one more thing. That is how a right gets buried under administration. And here's what shocked me. In New York City, gun license applicants have alleged that delays stretched from 12 to 18 months, even though state law set a 6-month deadline for deciding an application and issuing a license if approved. Think about that. If those allegations are true, then the issue is not confusion. It is not a 1-week backlog. It is a system running on a timeline far longer than the one the law itself appears to allow. Some applicants allegedly waited months just for fingerprint appointments. Others said that after finally getting fingerprinted, they were told an investigator might not even be assigned for many more months. Then, after all that silence, they could be given just a few business days to send extra documents. That is the kind of process that drives normal people insane. And from a legal point of view, it raises a brutal question. If the state says you have a right, but the office handling it moves like molasses, is the state really honoring that right at all? Now, quick legal note, this is educational information, not legal advice. Always consult an attorney for your specific situation. But wait, there's something even more important. The Supreme Court has already seen related carry fights coming out of New York after Bruen. In the Antoniuk litigation, the court did not hand down a final ruling on all of New York's post-Bruen carry restrictions. That part matters. A lot of people online skip that detail. The justices did not say, here is the final nationwide rule and every issue is settled. Instead, the New York battles kept moving through the lower courts. At one point, when emergency relief was denied, Justice Alito, joined by Justice Thomas, basically signaled that challengers should not be discouraged from coming back if the lower court failed to move in a reasonable time. That is not the same as a final win, but it is a flashing signal that the Supreme Court is watching. Why does that matter to you? Because it tells local governments something simple. If you play games with carry rights after Bruen, you may not stay hidden forever. The court may not step in every day. But it has already marked delays and abusive systems as a real constitutional problem. Here's what most people get wrong. They think the fight is only over whether permits should exist. That is actually the wrong first question. The first question is whether a permit system works in an objective, honest, timely way. A state may still argue that some permit systems are allowed. Bruen left room for that. But Bruen also warned that the room is not unlimited. Once delays get extreme, once fees get absurd, once the office becomes a maze, the state starts looking less like a neutral regulator and more like a wall. Imagine you are at a traffic stop. You are trying to stay calm, you believe you followed the law, but your permit application has been sitting untouched for 10 months. You have no license yet because your city will not act. You cannot carry legally. You cannot protect yourself the way the court said ordinary people can. And if you make the wrong move during that period, your problem is not political anymore. It is criminal. That is why this issue matters so much. Delay is not just inconvenience. It changes how you live. Now, this is where the story gets bigger than California or New York. Once the DOJ sues one major agency for permit delays, every other sheriff, police department, and licensing office in the country should be paying attention. Even if your local office is not in court today, the theory is now out there. If your office takes forever, demands endless extras, or effectively shuts down approvals, it could become the next test case. And that should matter whether you are pro-permit, anti-permit, or somewhere in the middle. Because if the government can stall one right through process, it can try the same trick with others. Today, it is carry permits. Tomorrow, it could be something else. That is why courts look hard at systems that appear neutral on paper but act hostile in practice. Hey, 73% of people watching right now aren't subscribed. Don't be part of that group. Join the gun owners who want these updates before the panic starts. Click subscribe because when the next court order drops, you want the facts first, not rumors 3 days later. So what should you watch going forward? First, watch for cases where applicants can prove exact timelines. Judges care about facts. How many months did the applicant wait? How many applications were pending? How many were approved? Were appointments available? Were calls ignored? Did the office break its own deadline? Those details turn internet outrage into courtroom evidence. Second, watch for whether more courts start treating delay itself as the constitutional injury. That would be a major shift. Not because it ends every permit system overnight, but because it forces licensing agencies to act like rights administrators instead of gatekeepers. Third, watch for more emergency requests to higher courts. Why? Because timing matters in rights cases. If a lower court drags things out, challengers often try to go upstairs fast. That is where the phrase emergency ruling comes from. Sometimes the emergency is not a final blockbuster opinion. Sometimes it is a fight over whether a bad rule or bad delay can stay in place while the case continues. And here's the part nobody's talking about enough. Even if the Supreme Court never says the words, all permits are over, a line of cases could still make abusive permit systems collapse in practice. Why? Because if courts say you cannot demand endless waits, cannot charge crushing fees, cannot invent vague standards, and cannot stall ordinary citizens for a year or more, then a lot of bad systems lose their power. They might still exist on paper, but they would have to work fast, clearly and fairly. That changes the real world. It means the single mom in a dangerous neighborhood cannot be told to just wait another year. It means the truck driver crossing rough areas cannot be trapped in licensing limbo forever. It means the veteran, the store owner, and the late shift worker do not have to beg for movement from an office that refuses to answer the phone. Now, let me be crystal clear so nobody clips this out of context. As of right now, there is not one clean Supreme Court order that instantly ends every public carry delay in America. That headline goes too far. But the legal pressure is very real. Bruen opened the door. The Supreme Court warned that long waits can cross the constitutional line. The DOJ has already acted against one major department over delays, and new lawsuits are trying to prove that some cities are still using bureaucracy as a weapon. That is why this story matters so much. We may be watching the next phase of the post-Bruen fight. Not just whether you can carry, but whether government offices can quietly choke that right by dragging their feet. Laws change fast, court orders change fast, and bad local policies can stay hidden until somebody drags them into federal court. Subscribe now, because the next video will break down the exact signs your permit office may already be violating your rights before it ever sends you a denial letter. So here's the big takeaway. The real story is not that every permit system just died today. The real story is that the Supreme Court already warned that extreme permit delays can be unconstitutional, and now lawsuits and federal action are testing that warning in the real world. Pause. If your local agency treats your rights like an endless waiting room, that system may be standing on thinner ice than ever before. If you want clear updates without the hype, hit subscribe right now and stay with this channel. I'd rather have you informed early than scared late. And remember, gun laws are different from state to state, and cases can change fast. So always check your local law and talk to a qualified attorney before making any decision about carrying or using a firearm.